Welcome to Heald Law Academy, the place to understand how to grow and protect your business. Today I'm with Ruth Burrell, who's a solicitor in the Commercial Property Department at Heald Solicitors LLP. We're going to find out about how landlords can ensure that their tenants leave their properties at the end of their lease term. Welcome, Ruth. Now, why is this so important?
Landlords like to have certainty when they grant a lease, and they want to know that if they grant a lease for 5 years, that at the end of that 5 years they're going to have their property back, that they don't want to have to go through a court procedure normally at the end of that 5 years in order to be able to take occupation of their property again. They might even have a tenant that they're not keen on, that maybe doesn't pay their rent very well, and they'll stick with them for the term of the lease, but they don't want them in there for any longer. So it just gives them that knowledge and that comfort that at the end of the 5 years or 3 years, they can take occupation of their property back.
Okay, now I know that you said landlords like certainty. Is there ever a situation where they don't have that certainty?
Yes, and the default statutory position is that all leases of properties occupied for the purposes of a tenant's business have security of tenure. This means that back in 1954, the government legislated that all tenants who occupy premises for business purposes have the right to remain in a property at the end of their lease. They also have the right to request a new lease if that's what they would like to do. So if the tenant doesn't voluntarily leave the property, then the landlord only has very, very limited options to ensure that the tenant leaves the property. And I've prepared another video setting out the options of the landlord.
Okay, so how could a landlord ensure that the default position doesn't arise?
Well, there's a very strict procedure which has to be followed to ensure that the tenant does in fact leave the property at the end of the term. But if the lease is completed and that procedure is not followed, then in fact the tenant, despite what the lease says, will have the right to remain in the property.
Wow.
So one of the most common ways that this arises is that a landlord thinks they're being helpful to a tenant by allowing them into occupation of a property so that they can start decorating, or sometimes even that landlords think it's only a lease of 3 or 5 years. It's not really worth the legal fees. I'll let them in under a license, maybe something printed off the internet, maybe something that they've prepared themselves, and they don't follow the strict procedure. This can then be deemed by a court to be a lease and in fact not a license. So in that case, the tenant will in fact have the right to remain in the property and request an actual lease of the property.
Gosh.
So the landlord could be quite stuck.
So can the landlord prevent the tenant from remaining in the property at the end of the term?
Yes, it would need to be agreed at the beginning. So when the terms are being agreed with the agent, it would need to be mentioned then so that the tenant knows that they are entering into a lease which won't continue beyond the term that is granted to them. So normally a landlord will be led by their agent, and the rule of thumb is that for shorter leases they tend to be excluded leases, which means that they don't have the right to remain in the property at the end of the term.
They have to leave.
They have to leave the property. And for longer leases, it tends to be that they do have that right to remain in the property. But that obviously needs to be agreed at the beginning. So if it is agreed in the heads of terms that the lease is going to be an excluded lease, then the landlord has to serve a warning notice on the tenant prior to completion of the lease to say that the lease is going to be excluded, that the tenant is not going to have those rights to remain in the property and won't have the rights to request a new lease. The tenant then has to sign a declaration to say that they understand this and to confirm that they know the rights that they're giving up are very powerful rights.
Sure.
And there are two types of declaration. A simple declaration, which is very rarely used. Most landlords will ask that the tenant signs a statutory declaration, because this means that the tenant has to go to an independent solicitor to swear it, to show that they've gone out of their way, basically, to say that they understand that they're giving up the rights to remain in the property. And one further word of warning, really, is that the statutory declaration and the warning notice need to be kept with the lease at the end of the transaction, because if they don't, they're the only piece of evidence that a landlord or a tenant has that they've been excluded, that the lease has been excluded, and that they don't have rights to remain in the property. And if they're not kept, then the tenant or any further tenant, if the leases are signed, could then try to claim rights to remain in the property.
Okay, so that covers all the areas. They can't say they didn't know. They've
Yes.
been to the solicitor and it's all agreed.
Yes.
Okay, so what happens at the end of the term of an excluded lease?
Well, provided that the warning notice has been served correctly and the statutory declaration has been signed or sworn, and everything's been kept together and we have all of the documentation, then the tenant has to leave the property.
Okay.
That's the standard position. The tenants may want to stay in the property, but this would mean that they would have to approach the landlord in good time to ask for a new lease, and a new lease could then be negotiated, but obviously it's entirely up to the landlord. The landlord may have plans for the property, he may have a tenant waiting that might be paying further rent, or he might want the property back for his own use. So it's entirely down to the landlord then. It's down to the landlord's discretion as to whether they grant a new lease. So if the landlord does agree to grant a new lease to the tenant and the terms of the lease are not agreed and the lease isn't signed by the end of the previous lease or the current lease, then a procedure is developed through time and through use in that a tenancy at will arises, so that the tenant can stay in the property while the terms of the lease are being negotiated for their new lease.
Okay.
So they don't have to vacate the property, go and find somewhere else to have their business for 6 months or so, and then move back. They can stay in the property while the terms of the new lease are being agreed, and normally that will be under the terms of the new lease. Normally the landlord will raise the rent, and so the tenant will be in paying that higher rent.
Okay.
But at least they have somewhere to run their business, and they're in the knowledge that a new lease will be granted.
Okay. If they do have to leave, how long do they have before they have to pack up and go?
If they are in a tenancy at will, it can be on the day.
On the day?
They don't have to, the landlord does not have to give them notice, or very minimal notice.
Well, thanks very much, Ruth. Okay, well, that's it for now. Remember to subscribe to all of our videos, news and events, and feel free to use our website or social media to ask any of our legal experts any questions you may have about commercial law. Bye for now.